Welcome to episode number 196 of AAA Weekly Webinar Series. Wishing you Happy New Year 2026, and we have crossed 2025 with lot many important judgments from Honorable Supreme Court of India. Some of these judgments that we covered in our earlier episodes, and we'll go detail by detail. Some judgments that we covered in our Courtroom Voices series. Whatever has not been covered and is found important, so that's what we are covering it today. And also we will cover the good judgment, landmark judgments from NCL 80 in our episode number 197. And do wait for that. That also would actually give us a lot of operational capabilities, because see, the NCL 80 is also giving judgments which are very, very helpful for taking decisions and for deciding strategies. So one very important judgment in this particular year was this Kalyani Transco versus Bhushan Power and Steel Limited. This was covered in our episode number 182 and episode number 161. So when originally this order was released, where the company was asked to go for liquidation, and it was a direction to the bench to pass an order for liquidating the company, and then there was a review, and then finally the resolution plan was approved in a review petition. So all this happened between 2nd May 2025, and then the subsequent order was 31st July 2025, and finally the resolution plan was approved on 26th of September 2025. So all this was covered. So this was the important judgment where actually we can say that the Supreme Court in fact has given clarity over various things, including adherence to the mandatory provisions of the IBC, including procedural irregularities and delay. So basically the resolution plan was rejected only because of the unprecedented delay for implementation. And however, during this review petition, finally it was held that the committee of creditors even exist during the implementation period also. So therefore, in case any decision has been taken by the committee of creditors during implementation, they have the commercial wisdom, and their commercial wisdom continues. So therefore, that resolution plan was approved, and the originally what NCL 80 held, against which the appeal was filed, that particular order of NCL 80 was upheld, and the resolution plan of JSW was approved. So this is what we have already covered in episode number 161 and episode number 182. Now another judgment which was good for real estate cases, that is Mansi Brar Fernandez versus Shubh Sharma, and that judgment was dated 12th of September 2025, and this was covered in our episode number 183. In this judgment, the court held that the applicant herein was a speculative investor, not a genuine home buyer. It held that buyback clauses, assured returns, post-dated checks, and parallel recovery actions indicate intent of investment and recovery and not the possession. The court reaffirmed that IBC cannot be used as a debt recovery forum, and admission requires a prima facie test of real intent. In case you want to go in detail about the arguments and observations of the court, then do watch episode number 183 of our AAA Weekly Webinar Series. Now the other judgment, which was delivered by way of a short video, and that short video was released on YouTube on 12th of September 2025, that was in the case of Amit Nera and others versus Pawan Kumar Garg. Now in this case, the Supreme Court held that home buyers cannot be denied flat possession if their claim were verified and admitted by RP. Now, in this particular case, the home buyer's claim was admitted in some other way. However, it was delayed and it was communicated also, but the committee of creditors actually excluded this claim because it was belated. However, it was indicated to the committee of creditors that this particular, or even the SRA, that there is a claim from home buyer in this manner. So that is also covered in short video, where the possession cannot be denied if the claims were verified and admitted by the RP. Now another judgment which is delivered on our YouTube as Courtroom Voices number 21. That is in the case of National Spot Exchange versus Union of India, and where this judgment is dated 15th of May 2025, and the Supreme Court in fact upheld the MPID, like Maharashtra Protection of Investors and Depositors Act. So that is where it relates to the protection of investors and the depositors over SARFAESI and IBC. So this was released on our YouTube channel on 27th of May 2025. So the Supreme Court held in this case that secured creditors cannot claim priority over assets attached under MPID Act, even though SARFAESI and Recovery of Debt and Bankruptcy Act RDBA statutorily recognize such priority. It held that MPID overrides SARFAESI and RDBA, that means Recovery of Debt and Bankruptcy Act, to preserve state legislative power and the federal structure. It further held that assets attached prior to IBC moratorium remains outside its scope and can be used for execution of decrees. So therefore, the MPID, the Maharashtra state government, was allowed to go ahead and attach or recover from the assets, and the claim under SARFAESI Act from the secured creditors or their recovery processes under the RDBA Act was considered as not overriding MPID. So another important judgment during this year 2025, which was released as Courtroom Voices number 22 in the case of Tata Steel Limited versus Rajkumar Banerjee. So this judgment was also given on 7th of May 2025, where the Supreme Court held, in fact, multiple times Supreme Court has held that NCLAT has no power to condone appeal filed beyond the maximum 45 days limit under section 61 subsection 2 of IBC. This was also released by us on YouTube on 29th of May 2025. Now coming to those judgments which are not so far covered by us in our episodes or in our courtroom voices or some of these short videos. Coming to these judgments which we would be discussing at little length, and the first such judgment is Independent Sugar Corporation Limited versus Girish Shriram Juneja. This judgment was delivered in the month of January 29th January 25, and it was along with 11 other appeals. Now, this was regarding interplay between IBC and Competition Act. In fact, this was a judgment where the majority of the judges were in fact against and minority was in favor. So we will discuss all that. And in the corporate debtor in this case was Hindustan National Glass and Industries Limited. In fact, this particular company was holding 60% market share in India's glass packaging industry, and the successful resolution applicant was AGI Greenpack Limited. AGI Greenpack Limited, so we'll call SRA in our communication. So the corporate debtor Hindustan National Glass holding 60% of the market share. So the Indian Independent Sugar Corporation Limited, and in short it is INSCO, a company, it submitted a resolution plan. So a resolution applicant, SRA, one of the resolution applicant, corporate debtor. So the fight is between the SRA and a resolution applicant and the corporate debtor. So without taking names, now we'll discuss the concept. Now the RP that we've already said, the Grish Sriram Juneja, the CIRP commenced, and all these facts are in fact not really very important. Now the NCLAT proceeding says that the resolution applicant challenged the COC approval because the COC approved the resolution plan of SRA and RA. So the other RA who is not successful challenged the COC approval, arguing the law, the proviso to section 31 subsection 4 of IBC requires Competition Commission of India approval to be obtained prior to COC vote. So the difficulty in this case was that the approval of CCI, Competition Commission of India, was obtained after COC approval of the resolution plan, whereas the section 31 subsection 4 says that it has to be taken prior to the COC approval. So the law is clearly written in the proviso that it has to be taken prior to COC approval. However, in this case, the COC approval came first and the CCI approval came later. So this was the dispute, and the resolution applicant, not the successful one, or I will call unsuccessful resolution applicant, challenged this approval of the resolution plan, and there were in fact many civil appeals were filed because multiple parties joined all this dispute, and the basic arguments was that the RP violated the provisions of section 31 subsection 4. RP granted preferential treatment and unwarranted relaxation to the SRA. Then the COC's commercial wisdom was compromised because they voted on a plan without knowing if the CCI would approve it or require drastic modification. Now, there was another second judgment of NCLAT, and there was a like set of appeals were filed. So what I'm trying to say, the CCI failed to issue a mandatory show cause notice to the target company, which is the Hindustan National Glass, notifying only the acquirer. The merger would create a monopoly, giving the combined entity a market share of 80-85% in certain segments, leading to an appreciable adverse effect on competition. So see, the question of law in this case was whether this proviso to section 31 subsection 4 is mandatory or directory. That was the question of law. Second question of law was whether CCI approval must be obtained before COC approves a resolution plan involving a business combination. Because see, in this case, the resolution plan also proposed a business combination, means merger. So when the resolution plan itself says that a merger would be required and the corporate debtor itself is holding 60% market share, so if both these like companies merge together, so it will hold 80-85% of the market share. So it will be a kind of situation which is appreciable adverse effect on competition. The contentions, of course, from both sides, there were various contentions, and finally the observations and the decisions of the Supreme Court, I would say, in a 2:1 majority decision, the Supreme Court delivered significant observations regarding the intersection of insolvency proceedings and competition law. The majority, like Justice Rishikesh Roy and Justice Sudhanshu Dhulia, held that the proviso to section 31 subsection 4 of the IBC is strictly mandatory, while minority Justice S.V.N. Bhatti viewed it as a directory. Now, the key observations are the majority rejected NCLAT's view that timing of CCI approval was flexible. They emphasized the rule of plain reading, stating that when the language of the statute is clear, it must be followed regardless of perceived inconvenience. The use of the word prior in the proviso must be given some meaning. The necessary CCI approval for resolution plans containing combination proposal must be obtained prior to such plan being granted the COC approval. The statutory provision and legislative intent unequivocally affirm the mandatory nature of the proviso to Section 31, subsection 4 of IBC. The court observed that the COC cannot exercise its commercial wisdom effectively if it does not know the CCI's final stance, including potential modification or divestment. I also feel that the COC has approved a resolution plan without CCI approval, and later the CCI does not approve it. So that actually means that the entire process will actually get completely disturbed. So therefore the prior word is very important. So therefore the Supreme Court said that prior is important. So therefore CCI approval is required before the COC gives approval. So this is, the court found that the CCI approval proceeds. The CCI approval process was flawed because it failed to show a show cause notice to the target company, notifying only the acquirer. Minority dissent opinion was the dissenting judge said and argued that interpreting the proviso as mandatory would limit the number of eligible applicants and hinder the primary goal of IBC, that is maximization of asset value. Now, the minority judge also kind of apprehended a situation that there are 2 or 3 or 4 applicants, resolution applicants. If everyone goes to CCI and if everyone proposes to merge, then the CCI will give approval to one or all. So therefore, in case the only one goes to CCI, so that means there is no competition. So that is also an opinion, because see, if a person has already got an approval from CCI and then thereafter he comes to COC, that means the COC has no option other than approving that particular RA. So therefore, this is also a conflicting opinion, that how can it happen that before COC's approval somebody will go and get CCI approval, and that too, how can we propose merger to Competition Commission of India when there is the resolution plan is not even approved by the Committee of Creditors. So these are issues, but finally the Supreme Court said the AGI Green Pack, that is the unsuccessful resolution applicant resolution plan, is unsustainable as it failed to secure prior approval from CCI. Consequently, the approval granted by the COC to the resolution plan dated 28th of October 2022 without the requisite CCI approval cannot be sustained and is hereby set aside and quashed. The COC shall reconsider the appellant's resolution plan and any other resolution plans which possessed the requisite CCI approval. So this is something which is an important judgment, but still practically it is both way it is difficult. In case we say that it is required, then the COC doesn't have any negotiation power, and in case it is not required, it can be approved after the CCI, and after the COC approval, in case we go to CCI, and in case it is rejected, then we again go back to the earlier more and more resolution applicants.
Next, we have a judgment which is Bank of Baroda versus Farooq Ali Khan and others. Again, a Supreme Court judgment which has been decided on 20th of February 2025. This is an interesting judgment where some Farooq Ali Khan, who was a personal guarantor in a matter which went into CARP, for a CD which went into CARP, the Bank of Baroda initiated personal insolvency proceedings against this gentleman, and the NCLT ordered under Section 97 and appointed the RP to file a report under Section 99. And what has happened is subsequently this Farooq Ali Khan went to the High Court and obtained a stay order saying that this insolvency has been started and proceedings have been started. And look, I have a letter which kind of talks about how some WCTL related loan, the guarantee was not applicable to that. So he obtained a court using the writ jurisdiction under Article 226 of the Constitution of India, and that High Court order simply asked the NCLT to stop the proceedings, and this way the NCLT ordered the stoppage of proceedings. Bank of Baroda then went to the Supreme Court and asked for and appealed this order of the High Court. And Supreme Court in this case has come down heavily on the High Court, saying that there is a procedure under the Insolvency and Bankruptcy Code where the court appoints an RP to investigate into the facts and the details of the matter, and then file a report under Section 99 for the NCLT to formally start an insolvency process for the individual under Section 100 of the IBC. And therefore, the Supreme Court said that there was no point for the High Court to interfere in this process, and this was the legal process, or this is the legal process under the code, and the High Court should not have entered into the constitutional jurisdiction prior to the resolution professionals report. Had the resolution professionals report come in, and at that point in time, again under the code, if the guarantor would have wanted to challenge the order under Section 100 of IBC, he could have gone to NCLAT. So that is where the court said that the Supreme Court said that there is no point for the High Court to interfere in this matter.
See, another important judgment which has been given by Supreme Court of India on 4th of March 2025 is pertaining to the insolvency of personal guarantors to corporate debtors. Now, the citation of this judgment is Saranga Anil Kumar Agrawal versus Bhavesh Dheeraj Lal Sheth. This judgment was delivered by Honorable Justice Vikram Nath and Mr. Justice Prasanna Balachandra Vadale, and this actually talks about the IBC moratorium limits on the Consumer Protection Act penalties. So basically it talks about the excluded debt. See, when we talk about excluded debt and excluded assets, so this is a very, very important judgment that this in this particular case, even the Saranga Anil Kumar Agarwal is a debtor, individual debtor, and he has a proprietorship concern like East and West Builders, and this is a real estate company. So there are many home buyers. See, actually, Saranga Anil Kumar Agarwal, in his capacity as proprietor of a real estate company, has violated various or delayed various possessions in real estate cases which he is not given. People have gone to NCDRC, the National Consumer Dispute Redressal Commission, and have taken some orders. There are about 27 orders has actually been passed by NCDRC against the debtor, means the personal guarantor, and all those orders are saying that he is liable to pay penalty to all these consumers under the Consumer Protection Act. Now, in the meantime, since he was also a guarantor to another company called AA Estate Private Limited, he was a personal guarantor, so that company, because that company also defaulted, so the State Bank of India started his individual insolvency as a personal guarantor to a corporate debtor, and following that default, when the application was filed under Section 96, this debtor, the personal guarantor, argued that this moratorium is triggered. Once the moratorium triggered, all his assets are protected. So therefore, he said that no proceedings can take place against me. So therefore, all those recovery proceedings under Consumer Protection Act, in those 27 cases, he was claiming that it should not be recovered from me because the penalties are a debt. These are financial fines, and this is something which is recoverable from me. and if it is something which is recoverable from, it is debt. But then court, let us see what actually the Supreme Court says. It's very important that civil liabilities, commercial liabilities, fines, there's a difference between all these. So when we see section 75 regarding excluded debts, it is very clearly mentioned that any fine is not a debt which can be covered in the individual insolvency. So that's an excluded debt. So finally, the Supreme Court said that this is an excluded debt as per section 75 of the IBC, and the moratorium is not applicable to excluded debt. This will be recovered, this can be recovered by those 27 home buyers as per the Consumer Protection Act orders from NCDRC. Now, the question of flaw in this case was whether the execution of penalty orders passed by NCDRC can be stayed under the interim moratorium provisions of Section 96 of IBC. The contentions, of course, there are various contentions from both the parties. I would actually be coming to the observations from Honorable Supreme Court of India. The court observed a fundamental distinction between the civil and criminal proceedings concerning a debt moratorium. So if it is a debt, the court observed that there are two kinds of debt. One is a civil debt and the other is a criminal debt. And finally, it observed that a fine under the Consumer Protection Act is a criminal debt. It is not a civil debt. And it specifically noted that the penalties imposed by NCDRC are not standard financial liabilities. The court held that the penalties imposed by NCDRC are regulatory in nature and arise due to non-compliance with consumer protection laws. These penalties are distinct from debt recovery proceedings under the IBC because they are meant to ensure compliance and act as a deterrent rather than merely settling a debt owed to a creditor. Then the scope of Section 96 moratorium was also discussed, and the court emphasized that the interim moratorium for individuals and personal guarantors under Section 96 is narrower than the corporate moratorium under Section 14 of IBC. A careful reading of statutory scheme of IBC suggests that penalties arising from regulatory infractions are not covered under the ambit of debt as envisioned under the code. The court reasoned that while Section 96 stay proceedings in respect of any debt, it does not provide a blanket stay on all regulatory penalties, as doing so would defeat the objectives of Consumer Protection Act. So there is no blanket stay on all regulatory penalties. Even if you are under moratorium, any fine or anything which is part of the excluded debt cannot be considered. A pivotal observation was that the damages and penalties in question qualify as excluded debts under Section 79, subsection 15 of the IBC, which includes liabilities arising from fines imposed by courts or tribunals, damages for negligence or breach of obligations. The court raised significant public policy concerns, noting that allowing a stay would create an unfair advantage for errant entities and allow them to evade their legal obligations under the guise of insolvency. NCDRC penalties do not constitute a debt as defined by IBC and are not protected by Section 96 moratorium. This was, therefore, the appeal was dismissed.
In Web of Goel versus Deputy Commissioner of Income Tax, DCIT, this is again a Supreme Court judgment dated 20th March 2025. And in this case, income tax dues were not included in the approved resolution plan under IBC, and it was said that these stand extinguished. This pertains to a CRP of Tehri Iron and Steel Casting Limited, a matter which was taken up by us at AAA. And here the resolution plan was approved in May 2019, and the approved resolution plan acknowledged a contingent liability of about 16.85 crores towards income tax department. However, no claim was filed. The resolution plan therefore had kind of said that these contingent claims, nothing was provided in the resolution plan towards the payment for the same. And several months after the NCLT approval of the resolution plan, the Income Tax Department started following up or started issuing new demand notices for earlier demands or demands which were pertaining to prior to the CRP period. And the NCLT is the first place where the resolution applicant went and appealed. NCLT dismissed and said that we don't have any jurisdiction and this should be taken up by the income tax authorities. NCLAT also dismissed it. Both the NCLT and NCLAT dismissed the matters, and the resolution applicant then went to the Supreme Court. Supreme Court said that one, the income tax demands are extinguished in this matter and there is no point of these demands. This is something which is really frivolous. The Supreme Court also came down heavily on NCLAT, criticizing NCLAT and NCLT conduct in this case. And with regard to NCLAT, the court found it perverse that NCLAT brushed aside binding Supreme Court precedents simply because they weren't cited before NCLT. And regarding NCLT, the court stated it cannot approve NCLT's approach of dismissing application as frivolous without considering its merits on recording reasons. 1 lakh rupees of cost that was imposed by NCLT when this matter was taken up at NCLT was also reversed by the Supreme Court. So I think we have orders of the NCLT and NCLAT were set aside. So any resolution applicant who has income tax related difficulties where they are not able to get relief under section 153A, I believe that NCLT is the domain where they should go with an application based on this judgment, which will probably give relief to the applicant.
See, the judgment that I am going to deliberate now is on the service of the Section 8 notice from an operational creditor claim. The citation of this judgment is Visa Coke Limited versus Mesco Kalinga Steel Limited, and this judgment is dated 29th April 2025, delivered by Justice J.B. Pardiwala and Justice R. Mahadevan. Now, in this case, like the demand notice as required under Section 8 was served on the key managerial personnel of the corporate debtor, and it was delivered at the corporate debtor's registered office, and the NCLT and NCLT finally said that it was technically erroneous and all that. So this is where the Supreme Court actually came for the protection and gave a lot of observations about the importance of service and how to apply such kind of requirements, and can actually be technical requirements be so important that it even denies justice to an appropriate person. Now, this background is that there was a supplies and there was some kind of delay in the payment, and the huge debt was collated, and then there were some kind of discussions, some emails, and some kind of discussions were going on regarding some change in the terms and conditions of letter of credit. So these emails were basically it was not a dispute, but it was some kind of arrangement was being discussed in the emails. However, no document was ever signed. Now, this Visa Coke issued a Section 8 IBC notice in Form 3 demand notice and delivered at Mesco's registered office demanding payment from the corporate debtor. Receipt of notice was not denied. Mesco argued before NCLAT and later as the Supreme Court that 2019-2020 email exchanges amounted to novation, like it was a kind of replacement of the original contract, and based on that original contract and the novation, the amount was not even defaulted. The default rate therefore was challenged. The tribunal has rejected Section 9 petition only on the technical ground of improper service of Section 8 notice without examining the novation or default date defense on evidence. The Supreme Court held that rejection on service technically was over technical. The service technicality was over technical, that service through KMP at registered office in official capacity is valid service to the corporate debtor, and that novation or default date and limitation are mixed questions of law, and the facts requiring evidence testing must be decided by the NCLT after the remand, and the Supreme Court therefore set aside the NCLT and NCLAT rejection orders and remanded the Section 9 petition to NCLT for fresh decision on merits uninfluenced by earlier finding to allow evidence-based determination of default, contractual terms, novation, acknowledgement, limitation. So the Supreme Court said that all these issues, number one, the date of default, the novation in the terms of supply, the acknowledgement of the liability, limitation, everything we are not deciding. We are simply saying that the order was passed that the service of the notice under Section 8 was not technically correct. So therefore it is too technical to reject an application on this. So the basic issue before the Supreme Court was whether a Section 8 IBC demand notice addressed to key managerial personnel but delivered at the registered office clearly demanding payment from the CD constitute valid service for maintaining a Section 9 insolvency petition. That was the question, and various arguments from both sides, and the Supreme Court observation I would give as which may be usable in all your insolvency proceedings. The Supreme Court discussed Sections 8 and 9 of the IBC and Rule 5 of the Adjudicating Authority Rules 2016, focusing on requirement of valid service of demand notice before filing a Section 9 application. The Supreme Court reiterated that failure to issue a proper notice under Section 8 notice can invalidate a Section 9 petition, but clarified that the courts must read the service requirement with purpose and substance, not technical form. So the courts must read the service requirement with purpose and substance and not technical form. So the Form 3 notice served on KMP at the registered office clearly demanding the payment from the CD constitute a valid service under Section 8. The court relied on the principle that procedure cannot defeat substantive rights. When no prejudice is shown by the debtors, it quoted a 5-judge constitutional bench decision in Sardar Amarjit Singh Kalra, who is dead, by Ehlers and others to support this. Now, this particular 5-judge constitutional bench judgment and a paragraph was quoted by Honorable Supreme Court. Laws of procedure are meant to regulate effectively, assist and aid the objects of doing substantial and real justice, and not to foreclose even an adjudication on merits of substantial rights of citizen under personal, property and other laws. Procedure has always been viewed as handmaid of justice and not meant to hamper the cause of justice or sanctify miscarriage of justice. The Supreme Court further reinforced a substantive right should not be allowed to be defeated merely on technicality, on service being treated as irregularity versus invalidity, the Supreme Court held. Therefore, in our opinion, the notice issued by the appellant to KMP, key managerial personnel of the corporate debtor, and delivered at the registered office of the corporate debtor can be construed as a deemed service of notice as required under Section 8, and as the Supreme Court clarified that default is statutory trigger for a Section 9I petition, not mere existence of operational debt, and the creditor must specify and establish a correct default date, otherwise the application is incomplete. The court noted that the creditors relied on the supply contract, and so therefore all these issues like novation, like the limitation, like the acknowledgement of the debt, all this was not decided by the Supreme Court, and it was, in fact, it was remanded back to NCLT so that a fresh order can be passed after considering all these facts on merit. See, important judgment regarding the uh, technical kind of non-compliances.
In INFS Financial Services Limited versus Adhunik Meghalaya Steels Private Limited, a judgment dated 30th of July 2025, the issue that came before the Supreme Court of India was that whether the balance sheet, even if it doesn't expressly name the creditor, can constitute an acknowledgement of debt. So here the NCLT and the NCLAT had decided that since the balance sheet was not acknowledging the debt, was not mentioning the name of the creditor, it cannot be understood as acknowledgement for extension of the limitation period under Section 18 of the Limitation Act. However, the Supreme Court said that the idea behind this acknowledgement is only extension of the time period, and it is not that the balance sheet should be the sacrosanct proof that the debt is owed. And in the submissions, it was also raised that the claim that ILNFS had made was way higher than what the balance sheet had acknowledged. So there was a difference in the amount. But yes, there was no specific mention of the creditor's name. But Supreme Court said that since the total amount payable under the balance sheet, which was being reported by the company in recent financial statements, included the debt due to IRNFS. Therefore, the debt was, or the limitation period was effectively extended due to acknowledgement of debt, even if the name of the creditor was not appearing in the financial statements.
See, in another judgment, the Honorable Supreme Court has held a very, very important issue, and that is regarding cumulative redeemable preference shares. Whether these shares are debt or not, even if a debt was converted into the CRPS, cumulative redeemable preference shares. Now, the citation of this judgment is EPC Construction India Limited, EPC Construction India Limited versus Matix Fertilizer and Chemical Limited. The date of this judgment is 28th of October 2025 by Mr. Justice J.B. Pardiwala and Justice K.V. Vishwanathan. Now, in this case, the background is EPC Construction India Limited, in fact, has executed various contracts, and the Matix basically setting up a fertilizer plant, and they supplied huge material, and something like 400 crores were outstanding, and then the Matix, in fact, also stopped getting some payment from their facilities from the banks. So, like they kind of entered into a rearrangement. Now, that rearrangement was that against that supply, the EPC construction supplied material to Matix, which is a fertilizer company. So, against this supply, which is about 400 crore, in case a part, which is 250 crore, converted into a preference shares like cumulative redeemable preference shares, and that actually will help the uh, Matix and increase their authorized capital, shareholders' capital, and will get the disbursement. And then I think the entire project can be implemented, and EPC also would get gained out of it. So it was decided, and an agreement was entered. 8% cumulative redeemable. The dividend was also kept, and it was supposed to be redeemed in at par at the end of 3 years, and a total amount of 250 crore was converted from operational debt to the cumulative redeemable preference shares with 8% with a redemption period of 3 years, and preferential rights for dividend in the winding up process also. EPCC company itself, the company, because the company supplied 400 crore and couldn't recover, so the EPC itself went into CIRP. Now, in the EPC company's financial statement, there is an asset standing as the preferential shares, which is the cumulative redeemable preference shares are standing as asset having a value of 250 crore at 8% dividend with 3 years redemption. Now, the RP, who actually was appointed on EPC, started a kind of recovery from Matix. And in case of no response, then an insolvency application was also filed, and therefore the issue before the Supreme Court, it was filed, and NCLT and NCLAT rejected Section 7 application and holding that CRPS is investment. It is a share capital and it is not a debt, and redemption was not due under the Companies Act conditions. Therefore, no default under IBC. And I hope you understand that even if it is redeemable in 3 years, and when we read Companies Act, the redemption can only be out of the either fresh issue of shares or out of the profits of the company. And as you understand, even the Matix was implementing a fertilizer plant, was also into a difficulty. So therefore, the redemption was not even eligible under the Companies Act. So therefore, it was rejected by NCLT, NCLAT also. So the issues actually before the Supreme Court was whether NCLT, NCLAT were right in dismissing Section 7 application by holding that cumulative redeemable preference shares was not a financial credit and this CRPS did not create a financial debt or default. Now, in this case, the various submissions like the court must look at real estate. See, like there are various submissions from both sides, and the Supreme Court has observed that CRPS issued to EPCC even by converting receivables is share capital, not a loan or financial debt. And therefore, a preference shareholder is not a financial creditor under Section 5, subsection 7. Amount paid up on preference shares are not loans. Dividends are payable only out of profits. Treatment in the accounts will not be determinative of the nature of the relationship. The court held that redemption of preference shares is governed strictly by Section 55 of the Companies Act, which allows redemption only out of profits or fresh issue of shares. And since these conditions were not shown to be satisfied, the CRPS redemption amount was not due and therefore not payable. So therefore, no default under Section 3, subsection 12 of IPC could be claimed at this stage. The court further says, trigger to initiate CIRP under Section 9 is occurrence of a default and not mere existence of debt. Issue related to financial default date and novation, if any, being a mixed question of law. So therefore, it was all rejected. So what I mean to say that this is complete, that the preference shares cannot be considered as debt, and redemption, if it is permissible under the Companies Act, under Section 55 of the Companies Act, then only it will be considered as a redemption and eligible to redeem. So then only it can be considered as debt after approval of the redemption.
Next matter is Jalgaon District Central Cooperative Bank Limited versus State of Maharashtra and others, decided on 20th of November 2025, so a very recent judgment. In this case, what has been decreed is that the statutory first charge created under Section 11(2) of the EPF and MP Act for provident fund dues prevails over the priority conferred to secured creditors under Section 26E of the SARFAESI Act 2002. So this is a judgment which will be detrimental to the interest of creditors. In this case, the facts are very clear that the charge was created by the bank prior to the date on which the dues had become outstanding. Still, the Supreme Court in this case, rather this was a CJI-headed bench, said that no provident fund will have precedence over the bank dues. So this makes it very important for bankers to make sure that the PF dues are being paid on time by the company. In case the PF dues are not being paid on time by the company, even in case they have first charge over the assets of the company, PF dues will get priority over other dues. So makes it really, really important for all bankers, financial institutions to do this due diligence, because earlier we had EPF dues and gratuity dues as priority over other dues under the IBC framework. Now we have a judgment where PF dues have been given priority over the SARFAESI law as well. And another thing which is important here is that workmen due were also contested by the workmen, that they should also be paid in priority. However, that the Supreme Court of India did not accept, and they said that if there is any money which is left after taking care of the PF dues and the uh, dues to secured financial creditors, then the wages can be paid. So wages is not something that got a priority over the dues towards the bank, where the charge was registered with the ROC.
The next judgment is on real estate case. This is regarding the development rights and protection of development rights under the moratorium. The citation of the case is AA Estate Private Limited, means AA Estate Private Limited, through its RP Harshad Deshpande versus Kher Nagar Sukh Sadan Cooperative Housing Society Limited. The judgment is dated 28th of November 2025, and it is again given by Honorable Justice J.B. Pardiwala and Justice R. Mahadevan. Now, in this case, society actually is a lessee from Maharashtra Housing and Area Development Authority, MAHADA, for 99 years lease, a plot of land. The society entered into a registered development agreement with AA Estate Private Limited to redevelopment of the property, and the building would be developed as Kher Nagar Sukh Sadan. So that's a project, and it is somewhere the development agreement was executed in 2005. Now, this is as old a case in 2005, whereas the lease was effective from 1980. So, from 1980 to 2005, for 25 years, there was no action on that particular plot of land. Then the action started, redevelopment agreement was executed in 2005. And then nothing happened for some time, and there was a supplementary agreement again with the same company, AA Estate Private Limited, that was in 2014. Look at the plight of home buyers. That's like the development agreement was there. So then it was further extended by 14 months. Now, the appellant in this case, the appellant means the AA, has made substantial payments in this case for the infrastructure and approval. However, not much has happened. So this AA, the developer, in fact, one CIRP started in 2020, but it was settled, it was set aside. Then after this was set aside, first CIP is set aside, the society in fact terminated the redevelopment agreement with AA Estate, means the applicant and the corporate debtor in this case, and entered into a fresh agreement with another company, which is another company, TriStar Development LLP. Now, there is a second CIRP which started for AA Estate, and the RP wanted to protect that development rights. saying that it is covered under Section 14 moratorium. Now, RP says that AA estate is a redeveloper. So the society is the lessee of the land. Now the RP says that the society has cancelled the development agreement and a lot of rights have been created and a lot of money has been spent. So therefore RP claimed that it cannot be done because of the moratorium. No, in fact, the society filed a writ petition before Bombay High Court, and Bombay High Court in 2024, in fact, disposed of the writ petition, making the rule absolute in terms of the prayers, directing authorities to grant approval for redevelopment within 2 months. Now, the question of law in this case is the Supreme Court observed that the present appeal, therefore, raises substantial questions of law concerning the interplay between contract, moratorium, and constitutional remedies and deserves to be allowed. Whether the development agreement constitute asset or property of the corporate debtor so as to attract the protection of moratorium under Section 14 of the IBC or not, whether the High Court was justified in allowing writ petition and directing statutory authorities to grant approval in favor of the respondent. Now, the contentions from both sides were in fact very lengthy, but I would actually be focused on the observations of Honorable Supreme Court. So the issue number one, the Honorable Supreme Court in fact observed that whether the termination of the development agreement dated 16th of October 2005 and supplementary agreement by respondent number one society prior to initiation of second CIRP was valid and effective in law. So that was the first question of law because it was the second CIRP and before the commencement of second CIRP, this was in fact terminated. And the decision was the Supreme Court held that the termination of the development agreement and supplementary agreement by the society was valid, lawful, and effective in law. The termination was carried out after due notice and was consequences of prolonged and inexcusable default by the developer who failed to commence or complete substantial redevelopment work for nearly 2 decades. The delay constituted a material breach, entitling the owner to terminate as time is of the essence in a redevelopment agreement focused on the timely rehabilitation of displaced members. The termination was based on legitimate grounds unrelated to insolvency and therefore NCLT lacked jurisdiction under Section 60, subsection 5, clause C of the IBC to interfere with it. The court held, in light of these authorities and the terms of the development agreement, the developer was granted only a limited license to enter and use the land for redevelopment. No estate, proprietary right, or transferable interest was created. Ownership and legal possession always remained with the society. Consequently, the so-called development rights of the corporate debtor constitute at best a contractual permission and not an interest in property within the meaning of Section 14(1)(d). So the issue number two, whether the development agreement and supplementary agreement constitute asset or property of the corporate debtor as to attract the protections of moratorium under Section 14, the decision of the Honorable Supreme Court was that the development agreement and supplementary agreement do not constitute asset or property of the corporate debtor within the meaning of Section 14 because it was already terminated before the commencement of CIRP. Section 14 is confined to existing, subsisting and enforceable rights. As on date of commencement of CIRP, mere expectant, contingent or uncrystallized contractual rights do not constitute assets. So therefore, since the agreement stood validly terminated prior to initiation of the second CIRP, no subsisting or enforceable rights survived in favor of the corporate debtor, the developer was granted only a limited license to enter and use the land. The ownership and legal possession always remained with the society. Development rights of a defaulting developer who neither secured possession nor undertook any redevelopment activity cannot be elevated to the status of an asset or property within the meaning of Section 3, subsection 27. Whether the High Courts were justified in allowing the lead petition filed by the respondent, the society, and the directing the statutory authorities to process and grant approvals, the court said the High Court was justified in entering the writ petition and issuing directions to the statutory authorities. High Court determined that the termination preceded the CIRP, making the bar under Section 14 of the IBC inapplicable. So this was a good judgment where the development rights, whether it's an asset or not, in the absence of any progress or any kind of effort by the developer.
We have Sri Karshni Alloys Private Limited versus Ramakrishnan Sadasivan. It's a 10th December 2025 judgment from the Apex Court. Talks about how the Supreme Court has dismissed an argument that which talks about how the forfeiture in the case of failure for the auction purchaser to continue the liquidation process. What happens here frequently, that we have also seen in many of our cases, is that the auction purchaser fails to complete the auction process and complete his commitments after finishing the EMD. When the EMD is about to get forfeited, the auction purchaser tends to use what is called is section section 74 of the Indian Contract Act, which talks about, or where some judgments in the past are there, Fateh Chand versus Balkrishan Das, Kailash Nath Associates versus DDA, where Supreme Court had earlier clarified that Section 74 would apply, and the cost or the compensation must be reasonable. So what happens in this case is that those auction purchasers who have had some amounts forfeited, they come before courts, before NCLT, NCLAT, or Supreme Court in this case, and say that too much money was forfeited and the cost which was, or the damage which was undergone by the seller or by the company during the process was not that much, so the entire amount should not be forfeited. So in this case, the Supreme Court of India has differentiated. They have said that this is not a process, or the forfeiture has not happened under a contract, and therefore Section 74 of the Indian Contract Act is not applicable on liquidation cases under IBC. They have clearly distinguished that this is a court-monitored liquidation process where the NCLT monitors the liquidation process, and this process, if there is a failure to pay and the auction documents and the auction process requires the EMD to be forfeited, Section 74 of the Indian Contract Act cannot limit the amount of forfeiture or allow a discount on the forfeited amount. As long as there is a default of the auction purchaser, amount forfeited can be the entire EMD or the entire amount given by them in case they have paid certain installments but not completed their obligation.
So these are the most important judgments of 2025 from Honorable Supreme Court. We have not discussed those judgments which are already covered in our earlier episodes or our Courtroom Voices series. I hope you would like this deliberations, and in case you like this, please spread it to your friends, whosoever has interest in IBC profession, and also subscribe to our YouTube channel, not for any monitoring purposes, but it will give you alert for such kind of sessions in future also. Thank you.